Hey everyone, and welcome. I am absolutely thrilled to have you here for this explainer today. We are looking at a truly fascinating piece of legal history, the 1997 Western Cape Constitution certification case. Now, I don't want you to think of this as some dry, dusty court ruling. Actually, scratch that. Think of it more like a high-stakes legal exam. Imagine an entire province turning in its massive final project, and the absolute highest court in the land pulling out a big red pen to grade it.
So, here is the million-dollar question we're dealing with today. How much power does a province really have before it crosses the line into full-blown independence? It's the core tension we're exploring, that incredibly delicate balance between a province's desire to rule itself and the absolute necessity of maintaining national authority.
To unpack this, we've got a clear roadmap. We're going to cover 1. The ultimate constitutional test. 2. The two-step rulebook. 3. What passed the test. 4. Where the province failed. And 5. The final verdict. Let's dive right in.
Section 1. The ultimate constitutional test.
Let's travel back to 1997. The Western Cape is attempting to write its very own provincial constitution, really asserting its unique identity within a newly democratic South Africa. But here's the catch. A province can't just write whatever it feels like. The national constitution allows provinces to draft their own constitutions, sure, but it acts as the ultimate grading rubric. Before a single word of a provincial constitution can become law, the Constitutional Court has to rigorously grade it and certify that it falls strictly within the permitted boundaries. There are no free passes here. And, you might be wondering, why does this power struggle matter to us? Well, because the level of control a local government has directly impacts our daily lives. It affects everything from how resources are managed to how our immediate communities are run.
Section 2. The two-step rulebook. Okay, let's dive into this rulebook. The court didn't just guess on how to grade this. They used a specific loophole found in Section 143 of the National Constitution. To see if the Western Cape stayed within its lane, the court used a strict two-step approach. Step 1. Does the National Constitution even give the province the power to write a rule about this topic? Step 2. If the province wrote something that clashes with national law, is it a permissible inconsistency? Because yes, believe it or not, sometimes breaking the national rules is actually allowed, provided it fits a very, very specific definition. And that definition revolves entirely around two words: structure and procedure. The National Constitution explicitly allows provinces to differ in their legislative or executive structures and procedures, but to grade the exam, the court obviously had to define those terms. Structure simply means the form or the component parts of a government. Procedure means the way those component parts actually function. The court relied on this brilliant analogy from Professor D.V. Cowan to clear this up. He noted that the word parliament designates both a static and a dynamic concept. Think of it like a giant machine. The structure is the static parts, the gears, the wheels, the raw materials. The procedure is the dynamic way the machine actually runs. If a provincial law didn't change the static parts or the dynamic running of that machine, it just wasn't allowed to be different.
Section 3. What passed the test? So, with our rubric set, let's look at the homework answers the Western Cape got completely right. What passed with flying colors? Quite a bit, actually. The province included a preamble referencing Almighty God, which the court noted is a ceremonial tradition that doesn't violate freedom of religion. The province wanted to call its legislature a provincial parliament? Totally fine. A name change is a matter of form, not substance. Handing out their own provincial honors? Sure thing. They also repeated several clauses from the National Constitution verbatim. As long as those clauses related to provincial governance, the court gave them a green light. Things like ceremonial names and repeating national laws simply do not threaten the national framework.
But then, we get to this number right here, 14. The Western Cape proposed a 14-member provincial cabinet, which was larger than the national defaults. And even more boldly, they wanted 2 of those members to be completely unelected individuals from outside the parliament.
Opponents immediately cried foul, arguing this violated democratic values. But, plot twist, the court disagreed. They ruled that changing the size and makeup of the cabinet perfectly fits the definition of a static executive structure. Remember the machine analogy? It's simply changing the component parts of the machine. The National Constitution explicitly allows provinces to design their own executive structures. So this really ambitious proposal was entirely legal. The Western Cape got an absolute A+ on this section.
Section 4. Where the province failed. Now, what's really fascinating here is where things fall apart. Because the court's red pen came out in a major way on a few critical issues. Let's look at those fatal errors.
The first massive failure was the electoral system. The national constitution dictates a strict proportional representation list system, basically one giant voting pool. The Western Cape wanted to chop the province up into geographic, multi-member constituencies.
The province argued, hey, an electoral system dictates who gets into parliament, so it must be part of the legislative structure. Nice try, but the court sharply rejected this. Their logic is pretty brilliant. An electoral system is just a calculator. It translates votes into seats. It doesn't actually change the nature, size, or function of the legislative structure itself. Because an electoral system is neither a structure nor a procedure, the province had absolutely no legal right to change it. Big red X.
The second major failure came down to swearing-in ceremonies. The national constitution states that provincial premiers and executives must be sworn in by the president of the Constitutional Court. The Western Cape, however, wrote that their leaders would be sworn in by the local judge-president of the Western Cape High Court.
It sounds like a tiny procedural difference, right? Why does it matter? Well, the court caught a massive overstep here. The president of the Constitutional Court and High Court judges are not provincial employees. They are independent national judicial figures. The crucial point is that a province simply cannot legally reassign the duties of independent national judges to suit its own local preferences. After all, you can't boss around someone who doesn't work for you. Another big red X.
And the third major failure involved ethics. The national constitution strictly prohibits cabinet members from doing any outside paid work. The Western Cape agreed, but they added a little clause saying that a future provincial law would locally define what paid work actually means. The court shut this down immediately. They emphasized that if every single province got to write its own unique definition for paid work, the national ethical standard would entirely collapse. What's considered corrupt in one province might be perfectly legal in another. A province absolutely cannot write its own definitions for national rules. Major overstep.
Section 5. The final verdict.
All right, the Constitutional Court has finished grading the Western Cape's exam. So, what was the final verdict? Well, because of these specific, glaring red lights, the electoral system, the oaths, the definition of paid work, the entire document failed certification. The rule is that the whole text must comply. Even if 95% of the Constitution was perfect, those fatal inconsistencies meant the court formally withheld certification. The Western Cape was sent all the way back to the drawing board to correct these errors before their constitution could become law.
Which leaves us with a really profound thought to ponder today. This case wasn't just about legal semantics, it was about defining the very architecture of a nation. How do we perfectly balance provincial autonomy with national unity in a constitutional democracy? It is a serious tightrope walk between allowing local flavor and preventing the whole house from fracturing. Thank you so much for exploring this incredible piece of legal history with me in this explainer today. Keep asking great questions, and I'll catch you in the next one.